And Mary's an 85-year-old widow. She's in good health. She has 3 children, despite what the handout says. It initially says 4, but she only has 3 children. And Mary comes to me because her husband died last year, and they both had wills, but now that her husband has passed away, she wants to have another look at her will and make some changes to it. Now, Mary likes to play bridge, and she plays bridge a couple times a week, and so a lot of talk goes on during these bridge games. And last week, Mary was at a bridge game, and someone began talking about how they had figured out a way to beat the government by transferring all their assets to their children so that their estate would not have to pay this estate administration tax. The estate administration tax is, roughly speaking, and I'm only going to use the approximate numbers, approximately 1.5% of the value of the assets held by a person's estate when the person dies. So, to give you an example, if someone dies and all of the assets in their name total $1 million, and they have a will, and when that will goes to court to go through what's called a probate process, at which a judge will approve it and issue a certificate to the executor. One of the things we have to do in that application is include a valuation of the estate. And in this case, if it was $1 million, then when we submit the application, we have to pay the tax at that time. And the estate administration tax on $1 million is approximately $15,000. It's about $15,000 per million. In other words, on $100,000 estate, it's going to be $1,500. So Mary's telling me that at this meeting, her friend was bragging about the fact that she'd gone to see her lawyer and they had transferred her home and her bank account and all kinds of other assets to her children so that when she died, there wouldn't be any assets for the government to tax. And that would mean that no estate administration tax would be payable because there'd be no assets left in her estate. Everything would have been given to her children before she died. And Mary thinks that's a great idea, and she's come to me for advice. Now, I also know from the past that Mary hates paying taxes. And of course, everybody hates paying taxes, but she tells me that she is so resentful of this estate administration tax that she's willing to do anything at all, legal or illegal, to not pay the tax. So we have to distinguish, and I have to distinguish to Mary between what is legal, which is called avoiding tax or tax avoidance, and what is illegal, which is called evading tax or tax evasion. Tax evasion, if you're convicted of it, there's a good chance you're going to land in prison, and it's going to cost you a lot of money on the way there. I, as a lawyer, I explained to her, cannot give you advice about how to break the law, but I can give you advice about how to avoid paying taxes by complying with the law, but finding ways to deal with what the law, with the obligations that the law imposes on you. Now, Mary's assets in the example that I'm using are as follows. She has a home that's worth $1 million. She has a RIF, Registered Retirement Income Fund, worth $500,000. She has a bank account with $50,000 in it. She owns all of the issued shares of a Ontario Corporation, a private company incorporated under Ontario law that her husband left her. And those shares hold investments that have a value of $800,000, which means in effect that the shares that Mary owns are worth $800,000. And finally, she has a 3-carat diamond ring, which is worth $50,000. Now, just to pause it, now she's pretty well off. But I you know, those are the kind of clients that we like to get. I want to pause for a moment to point out how these assets are held. Specifically, we have to distinguish between assets that are held at institutions and assets that are not held at institutions. The assets that are held at institutions would include her home, and I say that because even though she's the registered owner of the home, ownership of the home is registered, as I think you all know, in the Land Titles Office. And the Land Titles Office is a Ontario government creation that is operated by the Ontario government and that holds virtually all of the land ownership records for every property in Ontario. So because the ownership is registered with this government institution, the Land Titles Office, we say that it's an institutional registration. Secondly, her RIF, Registered Retirement Income Fund. These are registered under the Income Tax Act and must be held through a financial institution such as a bank or a stock brokerage. And in Mary's case, hers is held at a bank-owned investment brokerage, and of course it's registered under the Income Tax Act. Third, she has a bank account, and of course that's held at a bank as well. So those 3 items are all institutionally held. The fourth item, the shares of the Ontario private company. In Ontario, as in many other jurisdictions, the ownership of shares of private companies is not public information. It's not registered anywhere in any public record, so we don't have to worry about any institution holding these shares. In fact, the shares are in the form of a share certificate, which are held in the custody of Mary's corporate lawyer at the lawyer's office, and it's an easy matter for the lawyer to transfer the shares if the shares are sold or if Mary should die and the shares have to be transferred to her executor. And finally, the ring, the diamond ring that Mary has, it's obviously not registered anywhere either. In this case, the ownership is Mary, and the ring is on her left ring finger. And you look at it, I can have a look at it, and it looks just beautiful. So, we're going to address some of the different ways that some of the different methods that we can use to minimize the amount of estate administration tax that Mary is going to pay. And I'm going to deal first with the one that Mary is all excited about, which is transferring her assets to her children. Any asset that's transferred to a child while Mary is alive, if that transfer is done properly, then the child becomes the owner of the asset. For example, her home. Mary wants to transfer her home into her own name and the names of her children as what are called joint tenants. Joint tenants simply means that the form of ownership is joint ownership. And with joint ownership, we have a legal concept called right of survivorship. If some of you own your own home and you're married, the ownership of your home may be held by you and your spouse as joint tenants. That's a very common waivable title for married couples and for common law couples. And in a joint tenancy, when one of the two registered owners passes away, by right of survivorship, the other joint owner automatically becomes the sole owner of the home. You don't need a will for this to happen, and the home never becomes an asset of the estate of the deceased. The home doesn't go through the estate. It goes by this concept of right of survivorship, which is contractual in nature. And the important thing to understand about joint ownership very simply is that as long as it has a right of survivorship, it's an alternative way to transfer assets to other persons when you die. And it can be done not only with real estate, but this type of ownership can also apply to bank accounts, stock investment broker accounts, and various other types of investments. So Mary wants to transfer ownership to herself and her 3 children as joint tenants. That means that if Mary dies in a few years, by right of survivorship, the ownership of the home will go to her 3 children automatically. The Land Titles Office records for this home will be amended after Mary dies simply by removing Mary's name from the ownership records. The lawyer doing this simply has to file a simple document called a survivorship application with the Land Titles Office, and it's done. There's no magic to it. And that passes title to the children, and because the home didn't go through Mary's estate, that $1 million worth of asset is not going to be subject to estate administration tax. $15,000 worth of tax is saved as a result. I'm going to have a lot more to say about joint ownership of assets toward the end. But suffice it to say for now, I want to explain how the concept works. You should know about it because a lot of my clients come to me having heard about this and want to transfer assets to their children. It's quite a common thing, and I often have to explain to them how the concept works and what the benefits and drawbacks are. Second way is for some assets you can designate a beneficiary. And so I'm sure anyone here who has a registered retirement savings plan or registered retirement income fund, if you're old enough, has probably named a beneficiary in the plan contract that you signed with the bank or wherever else it's held. And to appoint the beneficiary, you simply fill in a space on the application that creates the account in the first place. And the beneficiary is then the person who will inherit the money in that registered plan after you pass away.
So you said that was an example of a bank account or the RIF?
Sorry?
You said this to assign a beneficiary is for a bank account or a RIF, is that what you said?
RRSP.
No, not for a bank account.
Oh, no.
RRSP.
Oh, RRSP.
For an RRSP or RRIF, which are typically held at
So
banks.
a RIF or RRSP.
Correct, but they're registered plans under the Income Tax Act.
Okay.
So you can designate a beneficiary. The most popular beneficiary designation by far is for married couples. Each will name the other as beneficiary of their RRSP. And there are practical reasons for this. among others, saving the estate administration tax. But by far the most important reason is that it is the only, it is the only commonly known way by which a person who has died can have their, can avoid paying income tax on the balance that is in their RSP or RIF. As long as you've named your spouse as the beneficiary, there is what's called a tax-free rollover. The spouse signs some paperwork, and the bank that holds the deceased's RRSP then transfers all of the assets in that plan to the surviving spouse's RRSP. No tax gets payable on in that situation.
So what if it's like your situation that you were saying, it's a sole survivor, like it's the mom, and she's naming the child as a beneficiary?
That's just what I'm going to get to.
Oh, okay, thanks.
So it works great with spouses. When we have a single individual who passes away, then there are two choices. You can name a beneficiary or not name a beneficiary. If you don't name a beneficiary, then your estate is automatically going to be the beneficiary of the plan. And when you die, in Mary's case, that $500,000 in the RRSP, RRIF, is going to become an asset of her estate and will be subject to $7,500 of estate administration tax. If Mary designates a beneficiary of the RRIF, then that won't happen. So, for example, if she names her 3 children as the beneficiaries of her RIF, then when she dies, the plan will be, the proceeds of the plan will be divided equally among the 3 children. The money never becomes an asset of her estate. It goes to the children as a result of the terms of a contract. It has nothing to do with the estate or Mary's will. It's, again, it's more or less automatic result of having named the beneficiary in the plan. So that's another great way.
Do LIRAs work the same way then? Do LIRAs work the same way, locked in retirement accounts?
I believe you can with LIRAs. I also believe you can with registered pensions.
Okay.
Excuse me.
Now,
I'm sorry, I'm just a little bit unclear. So if Mary designates her children as a beneficiary, is there an administrative tax, estate tax on that? Or is there any type of tax?
there's no administrative tax. There's no
Is there
estate tax because because the money never becomes an estate asset.
Okay, so but it doesn't have the funds from Mary's, say for her RRSP, do they have to go into the, like an RRSP for the children?
No, no.
So
In
they
fact,
can-
they can't. There's no rollover, and unless the children have a lot of contribution room in their RSPs, they're going to end up taking the money out as cash. What happens in Mary's case, because she's single, if she leaves if she designates her children in the RIF as her beneficiaries, and then she dies, the full amount of $500,000 is immediately subject to income tax. That's because contributions to registered retirement savings plans are not a permanent way of saving tax. They are a way of deferring tax until your old age. If you happen to die early or with a great deal of money in your plan, all of the money in the plan is income to your estate in the year of your death. So if Mary dies tomorrow, she has an extra $500,000 of income to declare this year over and above the other income, pension income, whatever else she's had to date, which means she is going to have to pay her estate is going to have to pay a big chunk of tax Typically, the bank, before distributing the funds to the children, will deduct 30% of the money in the RRSP and remit it to CRA under the bank's obligations under the Income Tax Act.
So let's just say one of the 3 children do have significant room for RSP deduction, that's already been deducted in advance.
The child can direct the funds to be paid to himself or to his RRSP, whatever he wants. But any transfer by a child to their RRSP is not a tax-free rollover. The estate first has to pay tax on the whole $500,000. The children are getting, after the $200,000 is $150 roughly $1,000 is deducted, the children are only getting the remainder of the money.
And still taxable after that, obviously, based on their income.
No, it's an inheritance.
Oh, it's inheritance,
It's
okay.
not income. It's not income, it's a gift, and gifts are not taxed in Canada yet. Well, they used to be.
Yeah.
Up till 1978 they were, but you're all too young to remember that.
So I'm a little confused, so the, if you designate the RIF, you avoid the 7,500, but you still have to pay the income tax.
If you're going to have to pay the income tax on a RIF, on the balance in a RIF when you die,
Yeah,
regardless of
Regardless,
whether you have
okay.
beneficiaries named or not.
I understand.
All right. The only purpose of naming the beneficiaries, the only purpose of a single person naming beneficiaries for their registered plans is that the proceeds will flow directly to the beneficiaries when the person dies and not go through the estate.
Right.
As a result, estate administration tax is saved, but that has nothing to do with income tax.
Right, okay.
Okay, income tax is a whole separate category that still applies. Hi, welcome to the meeting. We're talking about estate administration tax.
Thank you so much.
All right. Beneficiary designations can be done not only with registered plans, but also with life insurance policies, and they very commonly are. Again, as long as a beneficiary is named in a life insurance policy, and then if the insured person dies, the insurance proceeds will go directly to the beneficiary. They'll never become an asset of the estate, and so those insurance proceeds will not be subject to estate administration tax. However, if there is no beneficiary named in a life insurance policy, then the money by default upon death goes into the estate of the deceased and will form part of the estate assets and will be subject to estate administration tax. So that's another example of where you always want to have a beneficiary named. Now, there's a lot more to naming beneficiaries for both registered plans and insurance policies, and particularly where there are children named as beneficiaries who are too young to receive the money right away. We will use another tool called an insurance trust, which is a pretty specialized type of instrument that it can be used, that is used partly to avoid state administration tax, and but it's quite technical. I'm not going to get into it here, but just keep in mind that when you have young children that you want to name as beneficiaries of a life insurance policy, it can be done, but it should be done with an insurance trust. Otherwise, if you die, there are going to be some serious legal problems to be dealt with. And finally, let's look at the shares. The shares of the company and the diamond ring. As we pointed out before, neither of these is held by institutions. The share certificate for the shares that Mary owns, and which represents ownership of those shares, is held at her lawyer's office, and she herself holds the diamond ring on her finger. So when she dies, the lawyer who handles the corporation will be able, upon receiving a copy of the will and some other documentation that they're going to ask for, will be able to transfer the shares to Mary's heirs directly. And it can be done in such a way that in fact, no institutional consent or participation in this is required, because, as I mentioned earlier, shares of private companies are not registered with any public institution. They're always held either by the shareholder or typically by the shareholder's lawyer or the lawyer for the company in their custody for safekeeping. The problem, though, is that even though you don't need an institution to transfer the shares, if Mary makes only one will that covers all of the assets of her estate, when she dies, she is going to leave in her estate $800,000 worth of corporate shares. And those shares are going to be subject to a state administration tax, which will amount to somewhere around $12,000. So to deal with, so now I'm going to give you a rundown of how we can deal with some of these assets. As we mentioned, if we use Mary's idea of having her home registered with in her children's names, then the children can become the registered owners of the home on Mary's death by right of survivorship. For the registered plans and insurance policies, as long as there are beneficiaries designated, then on Mary's death, the proceeds of those plans or policies will go directly to the beneficiaries. In both cases then, in both those two cases, we have successfully avoided legally paying estate administration tax. The shares of the
Can I just say something about that? If they do, if she does put the right of survivorship in her children's name, and the children haven't purchased the home yet, then they also lose their exemption from the home buyer's plan.
I'm going to get to that.
Okay.
There are a lot of drawbacks to that,
Yeah.
right? And I'm going to summarize those up very shortly.
Okay, thanks.
For the shares of the company, here's how we deal with that. We make a second will. The first will deals with all of Mary's assets that are held by institutions. The second will deals with all of Mary's assets that are not held by institutions and therefore don't require any special court appointment of the executor in order to be carried out. For example, Mary's diamond ring. When she dies, someone's going to take it off her finger and presumably give it to the executor. And the executor is going to deal with it under the terms of the will. As long as the executor is satisfied that there are no disputes regarding the estate and that the executor is competent and so on and so forth, then the executor will either sell the ring and divide the proceeds among the beneficiaries, or will give the ring to someone that Mary has designated in her will to receive that ring. The point here is that because the ring, as a practical matter, can simply be given by the executor to someone or sold with the money distributed, no institutional participation in this process is necessary, and so you don't need the certificate of appointment of a state trustee that you get from the court probate process in order to carry this out. Similarly, we have a similar kind of technique that we use with. Let me go back one step. To deal with personal property and the shares of private corporations, as I mentioned, we make a second will. Well, I like to call it a corporate will. The corporate will is a will that deals only with, in this case, the shares of Mary's company, which are owned entirely by her, and with all of Mary's personal property, including her diamond ring. The first will deal, as I mentioned, with everything else. When Mary passes away, the first will, which deals with all the institutional assets, such as her home and her bank account, that will need to be processed through the probate process. A court appointment of the executor will be required, and once the certificate of appointment is issued by the court to the executor will have the legal authority to transfer ownership of the home, to transfer ownership of the bank account, and any other estate assets. That's what the institutional will does. The corporate will keeps the corporate shares and personal property under a separate section of Mary's estate. The corporate will never has to be submitted for the probate process. And unless there are particular reasons that the executor decides it has to be submitted, everything else being equal, no disputes among beneficiaries, and no other legal problems with that will. That will can be given to the executor, and the executor can carry out the instructions in the will with respect to the corporate shares and the personal property without going through the probate process. Because those shares and personal property haven't gone through the probate process, they're not assets of the estate that have to be declared when the application to the court is made. They're not, as a result, they're not part of the estate assets on which estate administration tax will be paid. So that's become quite a popular technique where an individual who dies has owned a private business that is worth a lot of money, as an example, or has similar investments in private businesses. Those shares can very often be transferred without the need to process them through the probate process. So what I've explained to Mary then is that she can transfer her home to her, an interest in her home to her 3 children as joint owners. But I want to talk to you more about that, Mary, because there are some drawbacks. In the case of your registered plan and any life insurance policy you might have, we're going to make sure that your beneficiary designation is up to date and is what you want, namely your 3 children, and that way we can transfer the assets in the registered plan to your children without going through the probate process. Again, no estate administration tax is going to be payable on that asset. For the shares of the company, we're going to make you a special will that will not have to go through the court probate process. The value of $800,000 attached to those shares, as well as the value of all your personal property, those are the things that are covered in this second will. Those will not have to be declared as part of the application by your executor to the court to issue a certificate of appointment, and so those assets will also not be subject to estate administration tax. And in effect, all of Mary's assets have been covered, and it looks like she's going to be in the clear. But unfortunately, I have to explain some facts of life to Mary. And the one problem with what Mary wants to do is transferring certain assets to her beneficiaries. And I'm going to generalize now. She can transfer not only her home, but her bank account and any other assets that she wants to her beneficiaries while she's alive. And it'll have the same effect, if done properly, it'll have the same result that when Mary dies, those assets held by her children will not be part of her estate. and so again will not be subject to the estate administration tax. So that's great. If those assets are worth $10 million, you've saved $150,000 in estate administration tax. That is worth a careful look at. But there are potential problems, and I'm going to go through those, give you a quick summary of them, because I know my time is almost up.
Sorry, where does the 150 come from?
Sorry?
1.5% on 10 million.
What's that?
Sorry, never mind.
All right. The risks of joint ownership of assets, specifically joint ownership by a parent and children is what I'm addressing here, but it can come up in other situations too. What happens if Mary decides, well, it's too complicated to have all 3 children named as owners, so she's going to leave, she's going to transfer her home to her oldest child, whose name is Claude, and Claude will become the registered owner, and Claude has promised Mary that when she passes away, Claude will sell the house and divide the proceeds equally among the 3 children. No, Claude is a real sweetheart. He's been close to his mother since the day he was born.
Real family matters.
Well, if Claude is an honest man, and I've seen, I've had plenty of cases like this come from my office, then in fact that's what will happen, and it frequently does happen. But just as easily, Claude can sell the house, pocket the money, disappear to the Cayman Islands, and there'll be nothing but litigation for years following, and all the surviving children will end up paying many, many times the saving in estate administration tax to lawyers, which is something that we in the legal profession, I guess, like, but it's not in the best interest of Mary or her estate. So that's always a big risk. Suppose she goes the more conventional route of transferring the title to herself and her 3 children as joint tenants. And as we said before, if she passes away, automatically by right of survivorship, her 3 children become the sole owners. Her interest in the home never goes to her estate, and as a result, $15,000 worth of estate administration tax is saved on this $1 million house. But the problem with putting ownership in the children's names is that the children all have their own homes. The home is only Mary's principal residence. Under Canadian tax law, the capital gain that you get when you sell your home is not subject to being taxed as long as the home was your principal residence throughout the time that you owned it. In Mary's case, if she transferred ownership of the home to herself and her 3 children 10 years ago, and it was in Midtown Toronto, and at that time it was worth, say, $800,000, by today it would have doubled. And the children are, if Mary dies today, are looking at an $800,000 capital gain on the sale of the house that has taken place entirely during the time that they owned the property. So the children are going to end up with tax liability for that capital gain that, again, will far exceed the amount of estate administration tax that Mary has had to pay, or would have had to pay on the house if she kept it in her estate. So income tax, another big issue. Creditors. What if Claude likes to spend money and has half a dozen Visa and MasterCard cards in his wallet and goes a little crazy and gets into very deep debt? What happens is the banks behind those cards will all sue him. There will be judgments issued in court against Claude, and those judgments can be registered in the land titles office in the form of what's called a writ of execution. That will attach to Mary's home, even though the judgment has nothing to do with Mary. Unfortunately, Claude is one of the registered owners of Mary's home, and the judgments against Claude will attach to any real estate that he owns, in the county or region where the judgment gets registered. Financial problems that arise later with your children can cause financial problems with your home, and the legal fees and the debts that you're going to be responsible for paying because of the lien on your home are going to far outweigh the saving in the state administration tax.
That's right. So when you
Bankruptcy along the same line is exactly the same problem. If one of the children goes bankrupt, their interest in the home may become an asset of the bankruptcy, seized by the bankruptcy trustee, and the trustee will either sit on that asset until the home is eventually sold by being registered on title in the land titles office, or will require that the family pay the creditors some money in order for the bankruptcy trustee to take that off the title. I think, let me run through first, and then I'll take some questions. Family law problems. Suppose one of the children is married and the child's marriage breaks up. The child is the registered owner of, one of the registered owners of Mary's home, and therefore owns a legal interest in it. The child's spouse may, as a result, claim that the child's interest in Mary's home is one of the child's assets and is part of the community property that has to be divided between the two spouses as part of the separation and divorce process. There's a chance that in fact Mary's home could become subject to another lien of some kind as a result of the divorce of one of Mary's children. Loss of control. With the children as three joint owners of the home and Mary the fourth, the children can outvote Mary on just about everything. So Mary can lose control of the home. The children may use techniques such as coercion to convince Mary to sell the home, and when they sell it, the three children own 3/4 of the home, so they're going to take 3/4 of the proceeds. And especially if mom is now, getting a little older and starting to have some problems with confusion and early dementia, mom may not even know what's going on by that time, a few years from now. We had a situation in our office, and I've heard of at least one other, in which the children, after they became owners of their father's home, evicted their father from the house. They physically took him out of the house. He had to go stay with neighbors until he could find another place to live. The children put the house up for sale and sold it and kept the money. It was unbelievable. The father came to one of the litigators in our office, and we literally had to sue the three children in order to get this resolved. And fortunately, it had a happy ending, if you can call a lawsuit a happy ending. But that's the kind of thing that can happen when children are given control of the ownership of a home. The next point, the state administration tax. Mary's 85 years old. She may live to 100. 5 years from now, she may decide, she's transferred the home to her children today. If she's done it the way I would want her to do it, she's also signed a trust agreement, which has a number of reasons for doing it, a number of purposes. And 5 years from now, after all this legal expense, she decides, well, it's time to sell the house. I'm going to move into a senior's residence and rent. So she lists the house for sale. She gets a great price. They sell the house. And all the money that was spent on the lawyer's fees, transferring ownership of the house and setting up this fancy trust for the children, all that money is basically wasted. It achieved nothing. So, it's one thing to put ownership of the children's home, of Mary's home into the children's names today. It's another thing entirely to do it when Mary is terminally ill and has only a few weeks to live. It makes a lot more sense at that point, from the point of view that regarding this one matter that I just discussed, because otherwise there is the possibility that the whole effort could be wasted if Mary wants to sell the house in the future. The last issue is land transfer tax. Prima facie, in other words, the default, is that when Mary transfers an interest to her 3 children, the children are going to have to pay land transfer tax on the property, on the value of the home, and that's a lot of money. Now, we can get around that in certain cases by characterizing the transfer as a gift, which is exempt from land transfer tax. But suppose one of the children has never owned a home before, and she and her husband are now buying a very expensive home in the city of Toronto, where we have double land transfer tax. Well, if that child becomes an owner of Mary's home, once they do that, they're no longer a first-time home buyer. And so when they go to buy their own home, the child will not get the benefit of the land transfer tax rebates that are available in Ontario and Toronto for first-time home buyers. The total of those rebates works out to almost $6,000. The child will have to forego that. So again, there is a significant cost to the transfer of the home into that particular child's name. Okay, that's basically what I wanted to cover with you. The point that I want to hammer home is that the idea that an elderly person can transfer their home to their children and thereby avoid estate administration tax is correct, but it's subject to a lot of potential problems, and very often the saving in estate administration tax that you project is not at all worth the potential heartache and financial cost if something goes wrong before the person eventually passes away.
The question I was going to ask was, when you were talking about the credit cards, the person has bankruptcy and
Yeah, lawsuits.
lawsuits against one of the child, right?
Mhm.
Can they also encumber the home, because they have legal title to
Well,
it, right? Let's say if they want to put a mortgage on it.
Yes, the child can mortgage his or her interest in the home
Right.
while an owner.
Right.
Again, that's certainly not something that Mary would have intended.
Right.
And it's not a very good mortgage, but there are some lenders that will accept something like that in certain
Don't
situations.
they have to get approval from the mother and the other 2
No,
children?
they don't. By mortgaging, if a child mortgages only their interest in the home, what they do first is they sever the joint tenancy. And severing the joint tenancy is a very simple process, which results in the home not being held as joint tenants, the way Mary intended, but being held as tenants in common, each of the 4 owners owning a 25% interest. Then the child can go out and mortgage their 25% interest only, because that's the only part of the home that they own. And they've created a whole bundle of legal problems for everyone, and have defeated the whole purpose of transferring the home to the children in the first place. Yeah, so that's another great example.
Is there something in wills in this case where if I have intent to pass things on to my children, and after I die, they start legal battles with each other, that I can say, look, whoever starts that legal battle is automatically excluded from the will?
Not that I know of.
I can't put that into my will.
No fights.
You can put it into your will, it's not going to carry anywhere.
Okay.